fifth case on this morning's docket. It is Cheney versus Poor, case number 110007. And I want to apologize to council for keeping them waiting longer than what I had anticipated. I know you both came a long way here, and I hope you didn't mind waiting about 90 minutes here in Wyandotte County. Any preliminary matters? Are you ready to proceed? Let's have the arguments, please.
May it please the appellant, Gina Cheney appears through her counsel, Andrew J. Walter of Ryan Walter McClimate, Norton, Kansas. And may I reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you, Justice. I'd like to start off by detailing some of the facts of this case, or maybe more of the procedure of this case on how this has gotten to this point. At the end of let's start at the beginning. The parties involved were never married. There was 2 children. One was born. The mother was pregnant when she started the relationship with the appellee, and that child was born. There's no dispute that the appellee is not the father of that first child. There was then a second child that was born, and there's no dispute that the father is the father, or the appellee is the father of that second child that was born. We had a hearing with the district court in Rawlins County, Kansas. At the close of the hearing,
and that hearing only dealt with the one minor child, correct?
Yes.
It did not. There was no jurisdiction or anything having to do with the child that was the product of the relationship. Is that correct?
The first child.
Go ahead.
Yes, the first child. There was an argument by the appellee that they did have rights to visitation with the oldest child. However, at the end of the hearing, the district court judge asked the appellant whether or not she was going to allow him to make a ruling on whether or not for visitation for the appellee and the older child. I then told the district court judge that we were going to object to him making any findings regarding the older child and visitation. The district court judge then asked if we were going to allow any sort of visitation continuing on that basis, to which I responded that we still would not allow the court to make a formal ruling regarding the custody of the older child and visitation for the older child for the appellee. However, we did inform the district court judge that we would still continue to allow visitation between the older child and the appellee on an informal basis. And so we were going to continue to allow visitation to occur in that manner, just not under court orders. After we made that statement, the district court judge then made a statement saying that he had intended to announce his ruling from the bench that day, but because of our stipulation that we were objecting to him making a ruling regarding the older child, he was going to have to reserve his judgment and take it under advisement. I think what's telling is some of the statements that the district court judge made after making that statement. His first statement was that his intentions was to allow both children to reside primarily with the appellant during the school year, and then both children to reside with the appellee during the summer. The district court judge then goes on to say that he thinks it's too bad that we were objecting to the court making a ruling regarding the older child, because he thought it was in the older child's best interest to remain with his sister. The district court judge then issued a memorandum decision approximately a week later. And let me clarify that no time during the original hearing to the district court judge did either the appellant or the appellee make any arguments as to the divided custody statute that was referred to by the district court judge in his memorandum decision. When the district court judge issued his memorandum decision, he makes several findings at the beginning. Then he goes through the laws that are applicable to the case at bar. First, he indicates that he understands that child custody disputes are governed by the best interest of the child. However, then he goes on to state that the appellee has no standing in regard to the older child and that he could not award any parenting time. After making that statement, he indicates...
Do you agree with that?
That he had no standing?
Right.
Yes, I do. He was never a stepfather. He was never married to the appellant, and so I don't believe...
And would you also agree that the statute requiring exceptional circumstances, 233207B, does not also apply in this situation?
I think that there's an argument to be made that it should apply.
Should, but maybe should, but why should it?
The reason I think that it should apply is because neither the appellee nor the appellant ever tried to argue that the divided custody statute was in play during the actual trial to the district court judge. It was not until he issued his memorandum decision where, after indicating that the appellee had no standing to the older child, that then he indicates that he understands that he cannot divide children except for an exceptional circumstance, and then he goes on to find that this is an exceptional circumstance. He then gives his reason why he believes that this is an exceptional circumstance, which is that it would be more stressful for the older child to see the younger child singly leave for visitation with the father on weekends. However, I believe that that statement itself, it was not supported by any evidence. There was no evidence presented by either party as to that occurrence going on, that either child would be stressful seeing the other one leave. And in fact, it actually goes against some of the evidence that was presented by the appellees.
Well, but you agree, though, that you argued against the court having the authority to allow or to have the is it Jocelyn? Is that?
I believe that's
it's
the name of the
Jocelyn,
child.
who is not the natural child of the relationship.
Yes.
You would agree that you yourself said, no, we're not going to give you jurisdiction in this case to extend it to her.
Yes, and
So the court didn't have any ability to order visitation,
yes,
or to isn't that right?
Yes, that's exactly
So it'd
right.
just be a completely voluntary act on your client's part, who could just solely create the terms of that one visitation.
Yes.
For Jocelyn, and
Yes.
not for Justine,
And that would-
excuse me.
That would be correct.
All right. So why is that wrong for the district court to conclude that?
Well, because the district court's the one that used the divided custody statute to justify his decision. He indicated that he could not divide custody of the two children without finding exceptional
Okay,
circumstance.
let's say the statute doesn't apply, then why is it an abuse of discretion to find what he found?
Well, because I believe there was an abuse of discretion, because his one finding, which is the only finding that goes towards the children, doesn't even involve the minor child that's involved in this case. The finding actually is in regard to Jocelyn and what would be detrimental to her. That finding is that it would be more stressful for Jocelyn to see the older or the younger child leave.
No, it'd be detrimental to both, though, wouldn't it? I mean, wouldn't it be?
The
It
judge
wouldn't be
never-
to Justine if she didn't have her sister accompany her on visitation?
That's not what the-
damaging to her?
That's not what the judge indicated in his finding. The judge indicated that it was only Jocelyn that would be more, it would be more stressful for Jocelyn if that occurred. And again, this is contradictory to some of the evidence that was presented, because the witnesses of the appellee actually testified that they did not believe, they were under the impression that there was no standing for the appellee to request visitation for the older child. And they even testified on that day that they did not believe that the two children should be separated. And so I believe that it's an abuse of discretion, because his only finding is not supported by any evidence. It's contradictory to some evidence. He actually, and it's also an abuse of discretion on a different standard, because he misapplied the law. He applied the exceptional circumstance law to this case. That's what he used to justify sending the children to two different homes. Even though the older child was not subject to this case and the court did not have jurisdiction, he still used that exceptional circumstance to find that it would be more stressful for the older child to see the younger child leave individually. And then, also, I believe it's abuse of discretion, because if you read through the memorandum decision that was issued by the district court judge, there's no indication at all that he took any of the factors that he listed into consideration when coming to this ruling. The only factor he took into consideration is what was going to be more stressful for the older child. He didn't take into consideration any factors in regard to the younger child. What as the Court of Appeals, in their opinion that was published in this, or not published, unpublished in this case that they issued, they cite several cases. One of them was Henry Taylor. And in Henry Taylor, the Court of Appeals goes on to state that it was that in considering some of the factors to determine best interest of the child, one of the factors is interaction with other people that the child's going to have interaction with. And the court in Taylor indicated that one of the factors, or one of the relationships that should be subject to that factor is relationship with siblings, whether it be half-sibling, step-sibling, or whatever. And if you read through the memorandum opinion, there's no indication that he took that into consideration at all. If you look at the evidence of this case, the evidence of this case is clear that these two girls had a very close relationship. There was nothing negative about the relationship.
I thought there was some evidence of the district court cited some stress in the relationship when it was found out that Mr. Poore was not the natural father of Jocelyn, and that created some friction.
I would say that that didn't create friction between the two girls. That created more friction between the older child and the appellee. And I don't think it would be proper for us to allow that behavior by the appellee to divide the two girls, because then we would be justifying inappropriate behavior by an individual of creating a rift between two girls in order to gain custody of the one that he had claims to, while not being able to gain custody to the one that he did not have claims to. And so any indication of the stress, that was only by actions of the appellee, and it wasn't due to the relationship of the two girls. The two girls, they're 3 years apart. They've never known a life not living together, except for the older one, obviously, for the 3 years until the younger one was born. They played together all the time. They shared a close relationship. They loved each other very much. Even the witnesses for the appellee testified that these girls were great together and testified that they should not be split up. When reviewing this, I believe that we have a difficult time in determining what standard of review to use at this point, because what I believe is that this case should be tested under the exceptional circumstance statute, because that's the statute that the district court judge relied on when granting his opinion and granting custody of the younger child to the appellee.
I'm sorry, now I'm confused. I thought that you said that that statute did not apply.
I don't believe it does.
Okay, then why would we review it?
Because
review the decision under that statute?
Because that's what the district court judge used to justify his decision.
Right, but if he should not have done so, wouldn't your argument be that there's an abuse of discretion if the incorrect law is applied?
And that's where I was getting ready to go. You just got ahead of me.
Okay, sorry.
That I do believe that if we had to justify it under the exceptional circumstance statute, we would have to find that there was sufficient evidence to support the finding that the district court judge made. I believe that there was absolutely no evidence to support that finding. And if we don't believe that that's the proper statute to apply, then we must determine whether or not this is abuse of discretion, which this court normally uses in child custody determinations. And I believe that the district court judge did abuse his discretion, primarily because he did.
I'm having trouble following you that he applied 233207, the divided custody statute, when his conclusions of law specifically cites, the only statute he cites to is the proper statute, which is 233203. Then he sets forth all the things that the statute sets forth that he has to consider. And then he considers those factors and makes a finding that to have both Jocelyn and Justine principally reside with the petitioner, with only Justine allowed to singly leave the home to exercise visitation with respondent, who is the only father of both girls who would be less favorable and more stressful than to have Justine principally reside with the respondent. Or with the, why is that not within the purview of the court to do that under the statute that he cites to?
Well, I believe that that part of the opinion is correct. However, if you go to paragraph 19 of the findings, It indicates that although this court recognizes and agrees that only in an exceptional case should the custody of minor children be divided, the court finds this to be an exceptional circumstance. And right there, I believe that is what he's using to justify his opinion, that this is an exceptional circumstance case, which he's using that exceptional circumstance.
Isn't the exceptional circumstance a higher standard than just the determining the custodial arrangement?
I believe it would take more findings.
So if he applied it and found a higher circumstance, why wouldn't it apply to then a lower standard?
Because then if we go to paragraph 20, that paragraph doesn't even deal with the child that is the jurisdiction of the court. That paragraph is only a finding in regard to the older child who is not subject to the court proceedings.
It has specifically to do with Justine Poor, who's the child of both parents. That's what that paragraph deals with.
And if that is my opinion is that paragraph, it reads to me as though he's indicating that it'd be more stressful on the older child to see the younger child leave singly by herself. And if that's not what he indicated, I again believe that this is an abuse of discretion because, again, this finding is not supported by any facts in the record. The only facts in the record that could even somewhat close to resemble this would be the stress that was caused between the older child and the appellee. It's not stress that was caused between the two children.
What remedy are you seeking?
I'm seeking that either the court reverse the decision on abuse of discretion standard.
And do what then?
And grant custody of the younger child to my client. Or in the
How can we do that? We can't do that.
Or in the alternative, that we remand this case and ask the district court judge to make findings that are appropriate in this case that actually are supported by the evidence that was presented.
Counsel, you're well out of time, and you had reserved 3 minutes for rebuttal. I'm going to ask my colleagues if we have any further questions. I see none. Thank you.
Thank you.
May it please the court, I'm Charles Peckham, Brown, Creighton, Peckham, Atwood, Kansas, appearing on behalf of the appellee, Zachary Poor. Basically, we're asking you today to uphold the ruling of the Court of Appeals, which upheld the district court. And I think one of the salient facts that is involved here is that from the word go, the mother in this case was only dealing with the Justine, the younger one. It was my client who tried to bring in both of them, and Ms. Cheney fought that very hard, saying the case is really only about Justine. There's no standing for my client because she's not a step parent, not a natural parent, not an adoptive parent to have anything to do.
Excuse me, Counselor, both children are natural children of the mother.
That is correct, sir.
And so if you separate them, then how can you say it has no effect on the older child?
We're not saying that. The problem is that the way the statute is worded and the fact that the appellant here pushed that from the petition on, where the petition only dealt with Justine, is that we're only doing here with this one child because...
Well, you would agree that 23-3207B is designed to keep siblings together and that you should only split them up if there are exceptional circumstances. Would you agree that that's the legislative intent behind that statute?
That is the intent behind the statute, but it used the word siblings. These are half-siblings, and as we stated in our brief...
As with regard to the mother, they're not half-siblings. They both are the natural
But there is
children.
no other parent of both children. There's only a parent of the one child. And as the Court of Appeals in this case referenced Henry Taylor, and we had also referenced 2 other out-of-state cases where
But my point is the effect's the same. If these 2 children are bonded and you separate them, the effect that the legislation was designed to avoid will not be avoided. Do you understand what the
I would
point I'm
agree with
making?
that, but by the same token, the bond between the older child and my client, which, you know, he had raised her since she was born, was the only father, and testimony at both sides agreed to that she had ever known, doesn't have any standing, and that was not important to the petitioner, who opposed the court trying to deal with that.
And so we penalized the child because the petitioner wasn't kind enough to give visitation. You see where I'm going? If we're looking at best interest of the child, why are we ignoring the best interest of the child?
We're trying to deal with the best interest of the child who was before the court. Unfortunately, the other child was not. So the court couldn't really deal with the whole area of the best interest of the one child before it, let alone the other one who was not there.
So you would say it's not in the best interest of Justine to maintain the bond and residency with her older sister?
It is in the best interest of Justine to maintain a bond with a sister, but the court determined, and the court did take a careful look at both the testimony as to the mother and as to the father, and decided, you know, both are equally, or, you know, certainly good parents. They're interested in the children. Both are entitled to custody, but he decided that given the overall situation, that the best interest of Justine was to be with Mr. Poor. I'm not suggesting he had an easy decision, but that was the best, given the situation that he had, where, you know, bonds are being ruptured, which is in every divorce case. And in this case, he used exceptional standard, though I would submit that the abuse of discretion is, as used by the Court of Appeals, is the proper standard.
Under our abuse of discretion standard, one criteria is for a trial court to abuses of discretion if they fail to apply the appropriate law. Do you disagree with your client that the judge did apply do you disagree with the opposing counsel that the judge did apply a statute that doesn't have any application here because of Jocelyn not being under the jurisdiction of the court?
It's a little unclear to me if the judge did apply that, or it was more of a comment that this is just, you know, this is an unusual case, because you don't normally have a case where somebody fathers a second child with a woman, yet who has also raised the first one. This is, you know, this is a tough case. But I do think, and as the opposing counsel has said, you know, neither one of us really dealt with this at all in the trial. That when you look at the statute, it is clear that 22, or 23, 2205, 2207, that Mr. Poor is not a parent within the statute as to, you know, custody and so on the other child, because he's just not a step parent, natural parent, or adoptive. So I don't think the statute really applies, though I think the Court of Appeals, you know, is correct in saying that that is one of the factors, along with many other factors, that you consider in trying to make a decision as to what is in, given what is never a good situation, what is in the best interest of the child that was at issue here.
And how do we handle an ambiguity in the order if none of us are sure whether the judge applied a statute that shouldn't have been applied? Is it better to remand it and make sure the judge's ruling is based on the correct legal standards?
Well, I guess several answers to that. One, I know at times that this court has basically upheld the right result on the wrong grounds. Bergstrom v. Noah, 266 Kansas 847, a 1990 case, just one of a number of cases where that's been cited. The second one is that there's also cases where the court has not articulated all the factors, but where they are present in the record that the appellate courts have upheld the decision there. And the court was clearly trying to look at all the testimony that had been presented on both sides, and he did note that both sides had somewhat, as is unfortunately common in divorce cases or custody cases, cut down the other. But he made the finding that both were basically good parents and able to have custody of the minor child. And that is basically, what our position is that the Court of Appeals should be upheld, that there was not abuse of discretion in what the district court did in making a tough call and placing the minor child that he had jurisdiction over with the father.
Any further presentation, counsel?
No, Your Honor.
Okay, do we have any more questions? Thank you, counsel.
Thank you.
One other reason that I do believe that this constitutes an abuse of discretion is if we look at the language that the judge used at the end of the hearing when he was making his announcements, and he indicated that he thought that this was too bad, that we were not going to allow him to make a ruling regarding the minor children, or the older child. Specifically, the district court judge finds in that paragraph, or at the end of his announcement, that it would be in Jocelyn's best interest to remain with Justine, the younger child. And so his finding that it would be more stressful to see them leave is just completely contradictory to his finding that he announced at the end of the hearing. And furthermore, he makes no findings in the case or in his memorandum decision or at the end of the hearing as to the effect that splitting these two girls up would have on the two of them. He doesn't indicate the sacredness of the sibling relationship, and that sacredness is, I guess, not as paramount as the stressful relationship that was caused by the appellee himself. And the finding in paragraph 20 that it would be more stressful to allow the child to leave singly is also contradictory to a statement that I made at the end of the hearing when he asked if we would allow visitation to continue, where I told the district court judge that we would continue to allow visitation on an informal basis. We just didn't want the court to make a specific...
But only within the unilateral power of the mother, correct?
And yes, that was correct.
So I'm just trying to follow your argument to its logical conclusion.
And
So your
Sorry.
client objected, you and your client objected to the court having any jurisdiction or exercising any control over the amount of contact that the other client could have with the older child. And yet you object to an exercise of control over the younger child that would take away choice on the part of your client.
the only
It seems to me that we'll let you decide the case. Is it really a correct legal position that your client say, Judge, we'll let you decide this case only as to one of these children and not as to the other, and then we will attack your decision if you don't rule our way on both of them?
No, and that's not what I'm trying to argue here. What I'm arguing is that his decision and his memorandum opinion that he uses to support placing the younger child with the appellee is that it would be more stressful to allow this child to leave singly without the older child being able to leave. If he hadn't made that finding, we wouldn't be attacking it on that ground. But the fact that he found that it would be more stressful for the older child to see the younger child to leave individually goes completely against the statement that we made at the end of the hearing.
Mr. Welder, I'm just wanting some clarification. did the judge make some initial preliminary findings? Is that what you're indicating? But he took it under advisement.
Yes, he did make a finding from the bench, because findings can be made both orally and in writing in the opinion. And I believe that he made a finding at the end of the hearing that he thought it would be in Jocelyn's best interest to remain with the younger child. And then he goes in his memorandum opinion and indicates that it'd be more stressful if they lived together. So I believe that those two statements in themselves are contradictory and alone show an abuse of discretion. I also believe that there's an abuse of discretion because of the judge misapplying the law, because I still believe that he applied the exceptional circumstance in dividing these two children. Otherwise, there would have been no reason for the district court judge to even mention that statute in his memorandum opinion and then go on to say that he understands that he cannot divide children except in an exceptional circumstance, and then goes on to find that this is an exceptional circumstance. If he wasn't using that to justify his opinion, there would be absolutely no reason for that to be in the memorandum opinion. He could just award custody as he believed under subsection A of that statute.
What's the current status of the children right now?
The-
Where are they at?
The older child is residing primarily with my client, and the younger child is residing primarily with the appellee.
So essentially, the order's been in place since this order, is that correct?
Yes, that is correct.
Since May of 2013, so a little over, about a year and a half, this has been the arrangement?
Yes, it is,
Okay.
that is correct.
Counsel, once again, I find you're well out of time. Would you like 30 seconds to wrap everything up before you sit down and perhaps head back to Northwest Kansas?
Well, I will be staying for the Royals game tonight, but I would appreciate a few moments. Justices, I do believe that there has been an abuse of discretion in this case on multiple different grounds. I believe that the one finding that the district court judge used to support his decision in separating the two children was not supported by any evidence at all. I believe that also it was an abuse of discretion because the district court judge misapplied the law. He applied the wrong law. He applied the law of divided custody and applied the law of exceptional circumstances. And finally, the findings that the district court judge did make not only weren't supported by any evidence, but are actually contrary to the evidence that was presented, specifically the appellee's own witnesses that testified that it would be in the best interest of the children to remain together. And with that, I thank you.
Thank you, counsel. We thank you both for your arguments this afternoon. Court will take this matter under advisement.